The Divorce Education Series presented by Findling Law. Welcome. I'm Daniel Findling. We're going to talk about the formal process in this webinar. This is a pretty comprehensive webinar. If you'd like an abbreviated version of what I'm going to talk about, just click on our website on the formal process. All right, let's get started. The formal process. The first step in any divorce after doing the initial intake. We're going to presume for our conversation that we already know who the parties are, what the nature and the extent of the estate is. And that would be to file the complaint for divorce and ex parte orders. Now, a complaint for divorce is a relatively simple document. You can get them in forms. Lawyers tend to create their own. They say things like we're in the right court, that there's been a breakdown in the marriage, that there's property and debts to divide. We don't really air your dirty laundry. We just say the basics, what it is that we want and that we want a divorce. Now, strategically, we may enter ex parte orders. Well, what are they? Ex parte means without another party present. And those orders typically are a mutual restraining order regarding property transfer and preservation of the marital estate. We don't want a party selling or encumbering or transferring assets during the divorce process. Or a financial status quo order. We want to make sure maybe that the dependent spouse continues to receive money as they have in the past during the divorce process. But we do not have to enter these ex parte orders. In fact, if we're representing the primary wage earner, often we make a decision not to enter certain ex parte orders. All right, so we filed the documents. What happens next? We have to put the other party on legal notice. That's called service of process. That is, we have to provide them with copies of the documents. After your spouse has been provided with copies of the documents, they have 21 days to file an answer to the complaint. Now, this is a burden. They must do it. If they choose not to do it, it's almost like a fork in the road. They make the decision, I'm going to blow this off. I'm not going to respond. Well, guess what? We're going to proceed without the individual under a theory called default, and it is very difficult to set aside a default. Once a judgment is entered, after 21 days, specifically after a judgment is entered, it's impossible to set aside a default. Virtually impossible. So the advantage of somebody not answering a complaint is that you can get whatever you want. Almost certainly. It's a very tough penalty. You must answer the complaint if you've been served with divorce papers, and if you file divorce papers, your spouse must answer the complaint. We will proceed without the individual if they don't. All right, discovery is probably the most important part of any case. You can think of discovery, almost take away the why in the word discovery. Why do we do discovery? To discover. To discover what? Well, in order to settle your case, we have to understand what the nature and the extent of the estate is. What is there to divide? In order to resolve a custody case, we have to understand the party's position as it relates to it. So we ask. We ask in a couple of different ways. Under oath, subject to the penalties of perjury. A subpoena is a court order that a lawyer typically signs, maybe to a credit card company. Please provide statements for the past 3 years. Or maybe to an employer, the gross compensation package for this employee. Interrogatories comes from that root to interrogate. Written questions under oath. We literally serve or give to the other party these written questions under oath subject to the penalties of perjury. Most people know what depositions are. Depositions, another discovery tactic by which you have a court reporter and you ask questions. So a subpoena, interrogatories, and depositions are all mechanisms by which we try to understand what there is to divide, and then you rely on the lawyer about how to divide it. Once discovery is completed, once the parties gain trust, that they understand what's on the table, that no one's hiding assets, that we know what the debts are, we know what the value of the home is, we know the parties' positions regarding custody, whatever may be relevant to your situation, then we start talking settlement. And if we're able to settle the case at any time, we can sort of skip ahead and oftentimes get a divorce not only cheaper, but also quicker. The first court date is a status conference. Other counties call it a case management conference. Really what the first court date is a date to get dates. That is, you go to court and you get a scheduling order. All right, discovery has to be completed by this date. We're going to have mediation if necessary by this date. Settlement conference by this date. Trial. The first court date is a roadmap for the rest of your case. Now, if you do not have any minor children and it's a relatively simple divorce case, and we've resolved the property disputes. That first court date could also be your divorce date. Pretty interesting. After 60 days, we can get you divorced if there are no minor children. All right, and in Oakland County, the first court date is called an early intervention conference. That's only with children. If you have children and you're filing divorce in Oakland County, you go to an early intervention conference. It's a meet and greet with the friend of the court. It serves the same purpose, as a status conference or a case management conference. That is, you get dates, but you also get to introduce yourself, and the friend of the court gets to introduce themselves to you, and they talk to you about the resources. Now, you also have to attend a SMILE conference, which stands for Start Making It Livable for Everyone. It's a educational program that parents with minor children in Oakland County have to go to, talking about the impact of divorce on children. So that first court date in Oakland County is called an early intervention conference. Mediation. Many cases settle without ever going to mediation, but oftentimes if the parties are still in dispute, let's talk about where we've gone so far. We filed the complaint, we served it, we got an answer, we've conducted our discovery, we've talked, and the parties have unrealistic expectations, or maybe an attorney has unrealistic expectations about the outcome of a case. A third-party neutral lawyer helps settle the case. They do not have an interest, and they sit down and they say, listen, this is what I think Judge so-and-so is going to do under these facts. You really should settle this case. The lawyers write a summary, and in many instances, a mediator, in almost 99% of the cases, are able to get the parties to settle their case. That's the purpose of mediation. If you settle at mediation, the next court date, which is a court settlement conference, becomes your divorce date in virtually every circumstance. But if you do not settle at mediation, the court's going to give it a go as well to see if they can settle the case. Maybe they're going to bring the lawyers back into chambers and say, why haven't this case settled? What is it that we need to do? What are the expectations? Well, maybe you know I'm not going to do this, or you know I do this in these cases. Try to motivate the parties to settle the case. If you do settle the case, well, at the settlement conference, it becomes your divorce date. If not, you go to trial. A trial, the judge makes a decision. Now, you can also see that I wrote arbitration on this slide. That's like mediation by binding. Oftentimes, parties contract to arbitrate the case, and the advantage of arbitration is that it's generally informal. The rules of evidence don't necessarily apply the same as they do in trial. The bad thing about arbitration is that it's final and non-modifiable. That is, once the arbitrator makes his or her decision, you're typically stuck with it with no right to appeal. Now, if a judge makes a decision, you have absolute right to go to the machine. Okay, let's talk timing right now, the timeline. This is really going to be a repeat partially of what we just talked about. Preparing the complaint and orders, it's typically done the same day clients come to our office. 90 days to serve a complaint. Oftentimes we say do it right away, but sometimes people want to do some investigation, maybe go to counseling, whatever the case may be. After someone's been served, they must answer the complaint within 21 days, and as we learned from the previous slide, failure to do so, default, you can proceed without the other individual. Discovery. Well, court typically sets that discovery cutoff at that first court date, that case management conference, status conference, or early intervention conference. Typically, we see 90 days to conduct discovery, understand what the nature and the extent of the estate is, do that investigation, that research, whatever it is, maybe even a business valuation if we have a large with a self-employed business. All right, that first court date is typically around 90 days from filing. Sometimes it's 60 days with divorce with no minor children. Sometimes it's a little bit later. Early in Oakland County, remember that's that status conference or case management conference in Oakland County. Also the meet and greet with the friend of the court, and that Start Making It Livable for Everyone. That meet and greet with the friend of the court and the education about the impact of divorce on children around the same time, about 90 days. All right, if you're unable to settle the case, now remember, we can always settle the case anytime during this timeline if the parties can agree. But if the parties don't agree, a third-party neutral lawyer is going to try to help the parties settle the case. Now, we mediate cases all the time here at Findling Law. We settle lots of cases, but we also try cases. And in fact, I'm always a big believer in this notion. The best way to settle a case is to prepare for trial, because that's your leverage. Settlement conference, usually the week after mediation. Trial or arbitration, typically between 90 days and 180 days, depending upon the case. If there are no minor children, we typically have a trial after 60 days, but before 6 months from the time. Minor children, you're not going to have a trial unless 6 months has passed from the date of filing the complaint for divorce. All right, let's talk about some key points, and this is sort of restating what we just talked about a moment ago. There's a 6-month statutory waiting period when there are minor children. Now, if we're able to settle the case, many courts will waive that statutory waiting period. We have to show that there's a compelling necessity, but for almost judicial economy purposes, they're going to let you waive the statutory waiting period. When there's no minor children, you cannot be divorced in less than 60 days. So when you ask, how long is it going to take me to get divorced? Well, you first have to assess if there are no minor children, 60 days minimum, less than 6 months. If there are minor children, 6 months to 1 year, but realistically, if you settle the case, many courts will let you waive that statutory waiting period and get divorced in less than 6 months. All right, let's talk about some key points here. Many people understand that Michigan is a no-fault state. That is, all you have to argue is that there's been a breakdown of the marriage and there's no likelihood that the marriage can be preserved, and the judge must grant the divorce. But notice on the slide I talk about no fault ground for divorce. That's different than no fault for divorce, because in fact fault can play a role in divorce cases, okay? The no fault ground only applies to granting the divorce as it relates to issues of custody, property division, alimony. These are all relevant when you talk about fault. So I always advise clients, and I'm advising you if you're listening to this webinar, don't engage in extramarital sexual contacts or affairs. And if you do, please use discretion, because it is relevant, it can make a difference, and it can affect the outcome of your. There are no defense to divorce. It takes 2 people to get married. Remember, it only takes 1 person to get divorced. This is just sort of real fault ground. 1 person has to allege there's a breakdown of the marriage. All right, so what happens if your husband or wife says, your spouse, I'm not going to sign the papers? It only takes 1 person to get divorced. What about service of process? Oftentimes people ask me, you know what, you're never going to find my spouse, or I don't know where he or she has moved, or they're not going to accept service. They keep running away. We will get the job done. There's alternative mechanisms to service. All we have to do is put people on legal notice, that we hope that it's actual notice, but oftentimes legal notice might include just posting it at the courthouse or sending it to the last known address. So evading service does you no good. Otherwise, what happens is that you'll wake up and you find out that you're divorced in a default situation, and that is never a good situation. All right? Relatively easy. What if someone says, I'm not going to give you a divorce? Well, we go back to that first lesson here, maybe one of the most important lessons, no fault ground for divorce. It takes 2 people to say I do. It only takes 1 person to say I don't. There is no way that an individual can legally prevent a divorce from occurring. If 1 party wants out, then the court must grant the divorce. It doesn't mean the court can't take other things into consideration, like property division, debt division, alimony, when deciding why an individual wants to divorce. But they cannot say no. A judge can't say, I want you to go to marriage counseling or something along those lines. If 1 party wants a divorce, you. All right. It is inevitable that you're going to have questions. Thank you for listening to this webinar. It's a complicated area of law. I've made it pretty easy for you to get a hold of me. You can call me. My phone number is on the screen here. Call me toll free at any time. You can email me. Email address is on the screen as well. Also, you can ask questions on our website at thedivorceguy.com, and we'd be more than happy to answer. We have a team truly dedicated to helping individuals through this process. Thank you for listening, and look forward to hopefully bringing you comfort. Have a great day.